Jack, welcome to Constituting America's Constitutional Chats. Could you please take a few minutes to give us your thoughts today on today's topic, and then we'll go to questions.
Happy to, and thanks for having me. Not a law professor, but maybe one day. Legal fellow is fine for now. So our topic this week, broadly speaking, is the power and influence exercised by unelected officials. The means we have for accessing this broader topic comes in the form of two Supreme Court cases, the Loper-Bright and Relentless cases that were argued before the Supreme Court just a couple weeks ago. Both of these cases are united in the fact that they challenge a longstanding legal doctrine known as Chevron Deference. Now, in the opening few minutes that I have here, I'm going to spend most of my time talking about the Chevron Doctrine and what it means, how it operates, and probably less about the specific facts of the case. The reason is that the cases, while they have their own peculiarities, are really before the court because they are vehicles for the court to revisit the Chevron Doctrine itself. So, what is the Chevron Doctrine? It's a rule that helps us to address the interpretive problems posed by ambiguous laws. Now, in law, we have a number of such doctrines that tell us how to approach ambiguous laws. We have really ancient ones like the rule of lenity, which says that ambiguous criminal statutes need to be interpreted in favor of the defendant. We have more recently the major questions doctrine. But Chevron, somewhat peculiarly, is not about how we interpret ambiguous laws. It is more about who gets to interpret them or whose interpretation controls. So what is the doctrine? In broad terms, the Chevron Doctrine holds that when a law is ambiguous, a court must defer to an agency interpretation of that law so long as the interpretation is reasonable. Now, there are a few other kind of bumpers and caveats on that. It's not just that agencies get to interpret any and every law. It has to be the statute that they administer, right? So Environmental Protection Agency doesn't get deference when it interprets the Securities and Exchange Act, but the SEC would. So what's the source of the Chevron Doctrine? It's not statutory, right? Congress did not write a law saying that courts you must defer. It's actually a judicially created doctrine. It comes from a 1984 Supreme Court opinion called Chevron v. Natural Resources Defense Council. This opinion was authored by Justice John Paul Stevens. It ended up giving rise, not immediately, but shortly thereafter, to a kind of two-step test that courts would employ, right? They'd ask first, is the law in question clear? And if it's not, is the agency interpretation reasonable? This is what's canonically referred to as the Chevron two-step. Why would courts create this to begin with? They don't just do this arbitrarily. There are two fundamental bases for the Chevron Doctrine. One is expertise, the other is accountability. So let's take expertise for starters. The presumption is that executive agencies have a kind of specialized subject matter expertise, experience, knowledge that makes them relatively more qualified to address unclear statutes than a generalist court, right? Judges go to law school. They don't get degrees in economics. They don't get degrees in environmental science, for instance. They are not subject matter experts, and presumably the agencies are. So expertise is one justification. The other is political accountability. Judges, at least federal judges, are appointed. They have life tenure. There's a little bit of politicking that goes on in the appointment process, but once they're on the bench, they're no longer accountable to voters. Neither are agencies exactly, right? Agency heads are political appointees. Agency employees, for the most part, are career officials. None of these people stand for elections, but most of them are within the executive branch. There is some political control, ostensibly, right? Less than Congress, but some. So we have political accountability and expertise are sort of the twin justifications for why we might have Chevron. And from these, there arises a kind of presumption that Congress, when it legislates in a way that's kind of ambiguous, that Congress would prefer agencies over courts to resolve the question, to resolve the ambiguity. So that's the background. And that might sound to a lot of people fairly unobjectionable. So why do we have controversy, right? Why do we have two cases at the same time before the Supreme Court asking the court to overturn this doctrine that is now nearly 40 years old? Well, there's a number of layers to the problem. I think we can start with the test itself. We can start with some of the conceptual problems in the Chevron two-step, right? So recall that what I said is that the first question is the law ambiguous? And is the agency interpretation reasonable? These are already very broad, dare I say it, ambiguous categories. And there is no set way to determine, one, whether there is a legal ambiguity to begin with, or two, whether the agency interpretation is, quote, reasonable. Reasonable against what should be the question that most of us are asking. There is no set standard for either of these. Some judges, when they encounter laws in agency cases, find ambiguity or gaps very readily, very quickly. Others find them almost never, right? There, a famous piece written by a former teacher of mine, Judge Ray Kethledge of the Sixth Circuit, who has been on the bench for quite some time now. He has notoriously never reached step 2 in a Chevron case. I mean, he has never found an ambiguity. So conceptually, even though there's a kind of clarity when one first looks at the Chevron test, it's actually not all that clear. We can move on from the conceptual problems to constitutional problems. How do agencies interpret statutes, or what form do their interpretations take? Oftentimes, it's in rules that bind not only other government actors, they also bind private parties. What does this look like? It looks suspiciously analogous to legislation. Agencies, as members of the executive branch, aren't meant to be legislators, right? Article 1 of the Constitution vests the whole of the legislative power in Congress alone. So when agencies are making interpretations taking the form of rules that bind private parties, again, it starts to look like they're doing Congress's job. Alternatively, what is interpretation, legal interpretation? It's something that, frankly, all three branches have to engage in, right? You cannot run a government without engaging in some level of legal interpretation. But who gets final, determinative, controlling interpretive authority? That's quintessentially a judicial function. What else do the courts do, right? What is the judicial power if it's not a final interpretive authority, right? And Article 3, much like Article 1, vests the whole of that particular authority in the judicial branch. So when agencies are interpreting, it starts to look like it's tugging at the edges of another branch's power, maybe even taking some of that away. But that's not where the constitutional concerns end. There's also a potential Fifth Amendment due process concern. Think of why we have courts. We want impartial justice. We want the parties appearing before courts to get a fair shake, a dispassionate, fair judgment. When you have litigation, like the litigations before the Supreme Court, where one party to the case is an agency, Chevron deference looks a lot like it's favoring one party to the dispute. So how can the other party really think that they're getting a fair shake in front of the court if the court's own rules say that one party's interpretation gets a favorable look? So those are some of the constitutional concerns. Now, lots of critics will fairly say that not everything needs to be elevated to the realm of a constitutional problem, right? Sometimes you can get at problems at a lower level. And that's true here too. We have a 1946 statute known as the Administrative Procedure Act. Yes, it's still on the books. Yes, it's still a good law. Yes, it should be relevant, but sometimes it doesn't seem to be. And that's particularly so in Chevron cases. So the Administrative Procedure Act was an effort by Congress to dispel some of the confusion about when or if courts should ever defer to agency interpretations. For the decades prior to this enactment, courts had done a variety of things in kind of piecemeal ad hoc fashion. There's some good scholarship out there tracing the history of what courts actually did when they deferred. But suffice it to say that by the 1930s, the New Deal, the progressive era, when new agencies were being introduced, there was confusion in the courts as to when they should defer to agency interpretations. The APA, the Administrative Procedure Act, was an attempt by Congress to offer a legislative solution. One of the things it said is that courts shall resolve all questions of law. It made no reference to deference, although it could have, right? It's aware of the problem of deference, but it gave no indication that courts were to give agency interpretations of law any kind of deferential treatment. Shouldn't that resolve the case? Some people think yes. One of the more interesting historical facts about Chevron is that, about 40 years later, a little less than 40 years later, when the Chevron opinion was written, not once in the opinion did Justice Stevens make reference to the Administrative Procedure Act. Kind of a telling omission. certainly relevant, but it doesn't seem the court dealt at all with this statutory command for courts to resolve questions of law. So maybe Chevron's problem is that it's contrary to Congress's statutory law. It may also have constitutional problems, but maybe we can get at the problem without having to go full-fledged constitutional in our criticism. You can get down to a kind of realist perspective and ask yourself, well, what are some of the incentive problems created by Chevron? Some of our listeners are probably familiar with the Federalist Papers. In Federalist 51, Madison talks about structural protections at the federal government level. Ambition counteracting ambition, right? Chevron pretty much inverts that, not entirely. It still leaves the executive branch very much with a form of ambition, but it sort of enervates the other two branches. Judges may defer simply to avoid busyness. The Supreme Court takes very few cases, but the lower courts, particularly district courts like the one where I work, can have lots and lots of cases going on at any given time. There's a lot of pressure to resolve litigation quickly and efficiently. Chevron, again, presents a seemingly straightforward rule. I don't think it's that straightforward in its application, but it's seemingly straightforward. And so judges, without having any kind of political ambitions or projects in mind, can simply find themselves wanting to defer to resolve the case at hand and move on to the next, right? So that can be a problem with the judicial incentives created by Chevron. What about the legislative incentives? We all know that compromise between competing parties is very difficult. Some people might say it's more difficult now than at other times, but it's always difficult. Anytime you have to submit your priorities to the attention of colleagues who don't share them, you're going to have to make some unpopular choices. What does Chevron do? Chevron in some ways provides incentives for legislators to avoid making any of those hard choices, to avoid any kind of tough political accountability. They can do so by legislating in what commentators have referred to as kind of a mood, right? You don't really give specific instructions. You just say, oh, EPA, clean up the air. You figure it out. Of course, I'm exaggerating, but only slightly. You can get away, if you're Congress, with kind of having broad goals out there and then leaving almost all the particulars of implementation, some of which are very, very consequential, to agencies to figure out, right? It can create this perverse incentive for legislators to be less active than they could. And like I said, the one branch that it does leave quite ambitious is the executive branch. The executive branch has sort of one figure, the president, who is kind of subject to public scrutiny, even though it has lots and lots of civil servants. And the president, he or she always has the incentive to look forceful and effective and to appear as though they are addressing constituent concerns. So president can look at a do-nothing Congress that doesn't seem to be cooperative or helpful, and say, you've got a lot of power there, you're not using it. If you're not, I'm going to take it. And you can tell me otherwise eventually, but until you do, or until a court does, I'm going to make use of it, and I'm going to implement my policy agenda. Why? Because implementing my policy agenda through the executive branch means I don't have to compromise. Right? I don't have to ask my friends in Congress to introduce a bill that the opposition then gets to shoot down or trim down and tailor. I get to have it all until the court tells me no. So some incentive problems there. Now, there's a temptation to make Chevron out to be the sum of all evils in the administrative state. That's not so. Even if the court takes down Chevron tomorrow, it's possible. It's going to probably trim the doctrine back in the next couple of weeks, at the very least. Lots of problems concerning the interactions between the executive branch agencies and the rest of the government are going to persist. Not least is the fact that Congress will still have the power to expressly delegate lots and lots of broad interpretive authority to agencies. So I don't know how I'm doing for time. It was probably a bit long-winded, but that is my starting survey.
Well, that's a great overview of a complicated issue, and you really broke it down well. Thank you very much. I know we've got a lot of questions, and so I'm going to go straight to Jewel and Jorn and let them come in first here with their questions.
Yeah, thank you for the overview and how clearly you laid out the Chevron two-step. Almost sounds like a dance. Could you? I'm surprised at how late this ruling actually was. Thinking about the administrative state and having talked about it on this show, this is something that actually was more so codified in this ruling later than I would have expected. So so that was 1980 what? That the ruling we're talking about mostly came down?
So Chevron v. NRDC was decided in 1984. Historically, the doctrine we're now familiar with didn't take shape for another couple of years, but yeah, 1984 is the Chevron decision.
Wow. Yeah, I'm surprised it was late. We talk about the kind of progressive tilt that happened in the earlier 1900s. So my first quick question is before this ruling, were the courts already starting to rule this way for a long time, and then we got a stronger ruling, or is this point like is this a big departure point that we see more of a break at this moment in legal jurisprudence before and after?
I would say that the birth of the Chevron Doctrine represents a distinct inflection point in the history of judicial attitudes towards agency interpretations. I think what you had, it might be too simplistic to break it down into three areas, but for our purposes, it might work. I think from, we'll say roughly the founding, but from the founding up through the early 20th century, you had a couple of kind of common law rules about when to defer to agencies. And they didn't always speak of it in terms of deference, but they were generally looking for a few different types of interpretations. One would be a long-standing interpretation, right? If an agency had long administered a single statute and had hewed to the same reading of it all the while, that was often something that courts deferred to, especially if, and this is the second factor, if that interpretation had been adopted at the time the statute was enacted. Right, so those were sort of the two factors that courts long looked at in determining if they were going to give controlling weight to an agency interpretation. So long-standing interpretations and interpretations that arose at the time the statute was enacted. Those were deemed to be pretty clear indicators that the agency was faithfully interpreting the law, which again, if we're talking about constitutional concerns, this is what executive branch agencies are charged with doing, right? Executing the laws faithfully. What happens during the progressive era? So like the Roosevelt administration, the 1930s, you have a kind of newly vigorous federal government that is addressing a series of national crises, most of them economic. You see a sudden proliferation. It's not the first time we see executive branch agencies, but you see a sudden proliferation of them. And so they're presenting a kind of new and acute legal challenge that courts are trying to deal with. You get a little pushback from the Supreme Court in the 30s. Schechter-Poultry is the one and only time, that and the companion case were the one and only time the court strikes down the law on non-delegation grounds, meaning that Congress literally gave away too much power, legislative power, to an agency. So you have this kind of confused moment in the 30s. And you have confusion among the lower courts too, where some of them are what you might call pragmatists, legal realists, as opposed to formalists. So they're much more concerned about whether government is in some broad sense working. I'm vastly oversimplifying their view, but they are less concerned with formal legal categories, and they are more concerned about, are the agencies addressing some acute public harm? So you get deference that's going beyond the traditional categories. You're getting deference to interpretations that are not longstanding or that might be totally new. And you get this, it's what prompts the APA in 1946. The APA does not do as good a job as one might have hoped in settling the question. You get divergent interpretations of what Congress did in the APA. I think the best view is that they wanted all questions of law to be addressed in the court's independent judgment without deference, but there are some countervailing arguments for why the APA still allows deference on the margins. So you get a few decades of courts going back and forth, disparate strands of case law that say sometimes deference, sometimes no deference. It seems to depend more on which judge you get. Then you have Chevron. And it takes, like I said, a couple of years because the decision itself does not write out this two-step test, but it doesn't take very long for that to appear in opinions. And so I'd say from the mid-'80s onward, we have lived in a Chevron world.
I'm pretty struck too by the way you described that, judges and the seemingly logical progression of that, since judges aren't experts in in some topic, well, we can defer that power to an agency in being able to interpret the law. It's that definitely seems like a pretty radical break from the way that that we normally talk about our government and our constitution and our governmental powers. Is that do you in a law sense, in a scholarly sense, do you see it the same way? I know that our expert this expert class is more of a new, and especially in that language, is more of a new development, I think, in political philosophy. You don't see that language among the founders, but at the same time, how different is an expert class from maybe an oligarchical class? So could you just say something about that?
Yeah, good questions all. I think you're entirely right that the language of expertise is really not a part of the founding era lexicon. It's not how the founders would have conceived the project of small r Republican and representative governance. They had a sense of merit, right? They wanted the most intelligent and most qualified people to be elected. But this notion of discrete kind of quasi-scientific expertise was not really part of their lexicon. You do see them using words like the new or improved political science. But I tend to agree with you that it's a vocabulary that would have been more or less foreign to them. It's a vocabulary that fits firmly within the political thought of the early 20th century, right? Again, agencies did not suddenly spring out of the ground, fully formed beginning in the 20th century. Some version of them, or at least executive departments, have existed since the founding. But it's in early 20th century political thought that we get this notion of expertise as a sort of independent basis for wielding political authority, precisely because expertise was seen at the time as a way of getting around the ugliness and difficulty of politics, right? Non-expert politics, value-based politics, politics conducted in a democratic polity where you couldn't necessarily assume that your average voter knew much of anything, right? That's long been a tension in having the vote widely available. Is that you're not always certain about the quality of the people casting them. It's one of the tensions all democratic republics have had to manage. So one of the answers in the early 20th century is, okay, we're going to take lots of questions away from the voters. They don't know anything about them. We're going to have a non-political class of subject matter experts figuring these things out, and it'll redound to everybody's benefit, right? You may disagree with the anthropology there, you may disagree with the political philosophy there, but this notion of expertise as a separate basis for political authority is very much a 20th century thing. It's become in some ways freestanding in ways that I think should concern us, at least insofar as we're committed to preserving truly representative democratic institutions. You don't want these things just to exist in a kind of desiccated form, but not really make any decisions, right? We can continue to have Congress, but more and more decisions get made elsewhere. And it kind of undercuts the importance of voting if ultimately the questions that we're voting on are going to get decided by somebody who's not elected. You mentioned...
Thank you. Jump on the end of what you were saying, because just gave me the thought of, you can find quote unquote expertise. I can find somebody better than me in this very small vein everywhere. So if I keep searching for expertise of this, I can make an argument that, oh, well, this group knows it only fills 2% of really what I'm looking at of the whole picture, but they have an expertise in that 2%, so I can pass the whole vote. I can pass the whole decision to them because I found this expertise. It just seems like a scary line, but please continue on where you're going.
Yeah, it's a concern that I share. I think that well, we don't want to be too cynical about the benefits of expertise, right? We do want to make use of more refined forms of knowledge that are out there. We also don't want to be like too deferential and, dare I say, like Pollyanna-ish about expertise. Not all experts are alike. Not all forms of expertise are alike. It doesn't make a lot of sense to conflate knowledge in a really sort of specific technical and material subject, like, a hard science. It doesn't make sense necessarily to conflate expertise in that area with expertise in, say, a social science, where the relationship between empirical studies and reality may be a little bit more attenuated. Again, it doesn't mean we discount it entirely, but we also don't want to just give it the mantle of authority simply because it comes wrapped in a PhD. That doesn't make a ton of sense.
Is this ruling that the Chevron ruling, is there anything in that which represents or references the authority and constitutionality of the agency system as a whole, of like what we may call an administrative state, or just the ability to make the administration? Is there anything in there which references that authority generation, or is it just really that's not at all in this ruling, and we'd have to go to previous cases to look for that?
So if I understood your question, this case is not a frontal attack to the constitutionality of agencies.
Mm-hmm.
Is that basically?
Yeah, I was wondering if it within the ruling, is there even a reference to the authority of the agencies? Is there something that at all basically justifies their authority, or just even says being as this is their authority, et cetera, et cetera?
So a few answers to that. It's agency authority is kind of a complicated question. This case, as I said a moment ago, does not present a kind of frontal challenge to their very existence. The fishermen bringing Loper, Bright, and Relentless are not saying the National Marines Fishery Service needs to be abolished. Simply not part of their argument. But there are, working in the background of this, are lots of assumptions about where agencies derive their power from. They're not necessarily constitutional questions. I don't think that the constitutionality of their existence is really implicated by these cases or by Chevron generally. But there is a question of where do they derive their authority from, and what's the extent of that authority? The simple answer, the kind of like law school textbook answer, is that agencies are creatures of statute. They have no kind of organic, natural source of power. Every power that they have or exercise must come from a statute, which in turn must come from Congress. And so that's very much what brings about this whole dispute, is sometimes courts behave almost as though agencies were states. States have the police power, right? We think of the federal government as being government of limited powers, at least that's how the founders thought of it. The states actually are not necessarily thought of as having limited powers. It doesn't mean that the powers are completely plenary, but the states have the police power, which means they have this kind of organic reservoir of authority to legislate on questions of morals and public safety, even when the federal government may not have that authority. Sometimes it almost seems as though courts are behaving the same way with respect to agencies. They say, yeah, there's a statute there. They were created by a statute. We get that. But basically, agencies get to do whatever is, like, let's say, necessary and proper to their purpose. That may not be a faithful reading of the statute that creates the agency, right? If you're just a purposivist, right? Somebody who looks at a law and says, all right, Congress's purpose in creating the Clean Air Act was to have clean air. End of story. Agency gets to do whatever brings about clean air. I like clean air. I want it. I'm not saying abolish the EPA, but I also do not want to live in the world in which EPA gets to do anything and everything it wants in pursuit of that, right? To answer the question of what powers do agencies have, we need to look closely at statutes. And then, importantly, and this is where Chevron comes in, when it's ambiguous or when there are gaps, this is one that scares me even more. And that's actually what's at issue in Loper Bright, is it's not even that there's a particular phrase in the Magnuson-Stevens Act that they're pointing to and saying this is ambiguous. They're saying that structurally, in between these provisions, there are gaps, and we, the agency, get to fill them with this new authority that Congress did not explicitly give us. I find that a little bit concerning because it doesn't take too much imagination to figure out how big we can make these gaps. If we're just interested in kind of imagining new powers. And I want to say again, you don't have to think of government or even agencies specifically as some kind of vast conspiracy to have concerns about this, right? Lots of very well-meaning, well-intentioned, and maybe kind of apolitical people, just sort of mission-oriented people working in an agency may think, gosh, I need to fund this at-sea monitoring program. That's what's at issue in Lopeb, right? We really need to make this work. It's important. Congress said it was important. We need to make sure our fisheries are preserved, right? That's a real issue. Fisheries can be overfished. They have been historically. We need to take some measures to protect them. But again, you can imagine a way to get yourself around this problem that may not be lawful, right? So it doesn't have to come from malign actors or people who want to destroy representative government. They're not thinking of it in that way, right? It's the aggregation of all these little decisions where people just say, I know what the purpose is. I'm just going to get there. And I don't really care about the legality of how.
It's almost like you brought us back to a term that I didn't bring back up yet, but looking at what structure incentivizes and what laws incentivize, and whether or not the motive may be good for the individuals in these organizations when you are able to yield government power, but you are an employee or have been appointed without being voted for, you are then incentivized to exercise maximum authority in that role because you are in the role. What else would you do? So it is that is a fascinating way to look at it, which you brought up about the courts sometimes treating them as states and police power. Not thought of it that way. That is extremely useful, I think, in our framing of the discussion. We want to turn to Lacey and see if there's any other questions that we have. This is a awesome show so far. I know that I bet our audience is bursting at the seams too. So I'll pass it on for now.
Thank you, guys. Thank you, Joel and Jorn. And once again, thank you, Jack, for coming on. So I'll be filling in today. So moving on, first off, I was curious if you could give a little bit more of a background on the case, particularly regarding the history of the fishermen and why they brought this case forward, just to paint us a bit of a broader picture and understanding Chevron.
Yeah, fair enough, right? It's always important to remember that cases have particular parties and facts. The case or controversy requirement of the Constitution means that there's always going to be some discrete, problem at issue. We may be talking about these things in sort of broad theoretic terms, but the court doesn't get to consider any of those unless there's a real controversy and people are actually being injured by some kind of government action. So as I've referenced obliquely a few times, both cases have been brought by fishermen. Both of them are active in the North Atlantic fishery. I think they're both herring boats. I couldn't swear to that part. It turns out that our nation's territorial waters and our nation's fisheries are divided into several different regions. They are subject to federal regulation. In the most immediate sense, I understand that the agency responsible for regulating them is the National Marine Fisheries Service. That agency derives its power from a law known as the Magnuson-Stevens Act. One of the things that the National Marine Fisheries Service does in order to preserve the nation's fisheries, make sure they remain ecologically sound and economically viable, is it has instituted, or I should say, it's not instituted, oversees an at-sea monitoring program. Congress has instituted the program, right? So that's one of the things to make clear is that the monitor program itself is not an invention of the agency, just, drawing on some sort of reservoir of undifferentiated power. Congress set this in place. Congress said we want monitors at sea, making sure there's compliance with catch requirements, right? Making sure that the way that the fishing is being conducted is consistent with regulations, make sure that the amount and type of marine life being taken out by the vessel corresponds to the relevant regulations and limitations. So that already puts fishermen in a bit of a tough spot, especially if you're in a smaller fishery. Apparently, there are some very large, commercially lucrative fisheries in like the Pacific Northwest. If anybody watches programs like Deadliest Catch, you probably see these big 100-foot boats, a bunch of crewmen on board, and heck, they can take camera crews aboard, so why can't they take a federal monitor? It's not the same in every fishery, I'm told. And the North Atlantic fishery involves much smaller boats, much fewer crewmen aboard. Just having another body there for potentially several days at a time is kind of a burden, but it's one that Congress imposed. The problem here is that in addition to having that body aboard, the National Marine Fisheries Service would like to force the fishermen to pay that monitor's salary, which is unsurprisingly a fairly expensive proposition. The plaintiffs in these cases did calculations that said it would result in a roughly 20% reduction of their profits if they were forced to pay for these monitors, who they are required to bring along on a certain percentage of their fishing trips. Now, Magnuson-Stevens Act says in certain instances that the National Marine Fisheries Service can require contributions from the fleet in order to fund the monitoring program. The primary source of funding for the monitoring program is congressional appropriations, right? I mean, that's really the primary source of funding for every government action is congressional appropriations. But as an adjunct to that, as a supplement to that, there are certain discrete instances in which the agency can require a capped contribution from the fleet. So I think the Pacific Northwest is one of those instances written into the law. It said it's capped at 2% of fleet revenues may be used to fund the monitor program. The statute is silent as to whether or not it can be, funding can be required elsewhere. Congress has apparently not been appropriating the necessary funds for this, for monitoring, or at least for a sufficient number of monitors. So the Marine Fisheries Service has been looking for several years for a kind of workaround. They've seen this funding problem coming. And so for the first time in their history, they decided that the Magnuson-Stevens Act actually gave them implied authority to impose fee funding on smaller fisheries, right? Fisheries that weren't covered by the relatively few provisions of the law that spoke to fee funding. And like I said, for smaller vessels like the ones at issue here, up to 20%. I mean, that's a huge, huge difference from the 2% cap that you have in the case of some of the nation's most profitable and large fisheries. So clearly the businesses are aggrieved, right? They're about to see an enormous decline in their revenues, potentially an extinction level event for their businesses. And they're wondering, where the heck does this power come from? Why do we have to bear this burden? They might think sure, they acknowledge that the fisheries being preserved is an important thing, but they don't want to be solely responsible for funding that effort. So they challenge the Marine Fisheries Service in district court. I think they're here. The one case went to the DDC. The other, I actually don't remember what district it originated in, but it was then litigated in the First Circuit. The agency says, well, Magnuson-Stevens Act is ambiguous as to whether or not we can extend this funding power to other fisheries. But we think it's a reasonable interpretation to say that Congress gave us this power, so we win under Chevron. Fishermen, of course, push back and say, no, this is not a real gap. It's not an implied delegation. You don't get deference for this. The DC Circuit splits 2-1. So the district court rules in favor of the agency. The DC Circuit splits 2-1 in favor of the agency and uses Chevron explicitly. Says that this is the basis for us finding that the law is ambiguous and the agency interpretation is reasonable. So the rule is okay. They get the funding. The court, I think the Supreme Court has been looking for a little while for a case that would allow them to squarely address the conceptual and legal problems posed by Chevron. They have passed on some other opportunities. Other litigants have asked them. And some of those cases have actually, there's not just been a petition to the court. The court has actually heard the case, but they've decided, this is not the time or it's not the vehicle for addressing the Chevron question. But the strange thing is that while Chevron remains very much a live doctrine in the lower courts, it's very popular with district courts, it's popular with certain circuit courts, notably the DC Circuit. It has been almost a ghost at the Supreme Court. I think we're going on something like 6 years since the court has actually relied on Chevron deference to uphold an agency interpretation. And it has passed in some really weird situations that you thought, oh, they're totally going to raise Chevron here. 2 terms ago, they had a hospital case called AHA v. Becerra. And everyone thought, oh, this could be a major Chevron decision. And no, silence. I mean, they resolved the case, but they did it just on straightforward statutory interpretation tools. So enter Loper Bright. and then Relentless, the case that came out of the First Circuit. And these seem to squarely present the kind of Chevron concerns that I think the court has been curious about, has probably been thinking through for some time, and understands that there's kind of a need to settle some of these questions, to settle the boundary, the interpretive boundaries that lower courts are going to be using in agency cases. So this is the moment. Why 2 cases? It's actually for similar reasons to what we had last term in the affirmative action cases. So Justice Ketanji Brown Jackson, who was formerly a member of the DC Circuit, was actually recused from the Loper Bright case. So she could not hear the merits. She just happened to be on the court at the time. I think she heard oral arguments, no kind of obvious conflict of interest. It's just, it had been part of her prior business. So once again, Chief Justice Roberts, I think, is interested in having a full quorum of justices to weigh in on this. So they took the Relentless case as a companion, and Justice Jackson was able to sit in on those arguments. The arguments are essentially identical. The lower court rulings differed slightly, but the arguments before the court were pretty much identical. So yeah, hopefully that's, again, I might have got on the long-winded side there, but that's kind of the overview of the litigation that actually brought us these 2 cases.
Definitely. Thank you for that. And even just looking forward, taking Chevron and the Frischman and everybody else, obviously this isn't the only case or legal precedent that's upholding the administrative state. There's a lot of policy issues ongoing. We've seen this since the growth in the progressive era and everything else. But what would you say if somebody were sitting there saying, okay, if we overturn Chevron, this isn't going to be the panacea? What other legal precedents are there that are really upholding this entire bureaucratic realm, administrative state, and what exactly can people do as a consequence of that?
Well, if somebody were to say to me that this case is not going to be a panacea, I say, well, yeah, I have to grant you that. I'm not pretending that this is. I think I said in my opening remarks, there's a tendency in not just in the legal community but in the broader public to kind of fixate on Chevron as the sum of all administrative evils. Again, assuming you're kind of admin skeptic. If you're pro agency governance, then you look at Chevron as kind of like a holy grail, and you're desperate to keep it. And I don't mean to diminish folks who look on things that way, because there are serious, albeit more pragmatic rather than legal considerations for why you might want to favor Chevron. But it's true. They could axe the whole thing, get rid of Chevron doctrine wholesale, and the administrative state would continue to exist. The consequence of these 2 cases is going to depend very much on what the court chooses to replace Chevron with. And there's a spectrum of options that they have available to them. This is part of why I previewed in my opening both the statutory difficulties and the constitutional ones. Suffice it to say that constitutional difficulties would require a broader reaching solution, right? It says something fundamentally about the interaction between the 3 constitutionally contemplated branches, and then what people call the headless 4th branch, but which is technically part of the executive branch. Constitutional problems would be more significant. So if a majority of the court sees this as a kind of constitutional problem, whether it derogates from Article 3 judicial power vesting or Article 1 legislative power vesting, or both, I don't know if they get to the due process concern. They don't seem as interested. But if it's a constitutional concern, then it's likely to be rooting out Chevron root and branch. Maybe no deference at all. We'd have what we'd call de novo interpretation, meaning in every case, the court just gives its best independent judgment of what the law means. Kind of sounds unremarkable. It's really what they do in all non-agency cases, but it's controversial in agency cases. If it's strictly a statutory difficulty, the solution may be similar in its extent, but Congress would then be free to, say, enact something like Chevron deference in statutory form. They may not get rid of deference altogether. They may say, okay, no more Chevron, but we're going to do a lighter form of deference. They may do what they did a few terms ago in Kaiser v. Wilkie, which involved a kind of related deference doctrine called our deference. I don't want to take us too far down a side path there, but suffice it to say, it's a similar kind of deference doctrine. What the court chose to do instead of getting rid of it is they really, really cabined it. They set all kinds of prior conditions on its use that meant it was going to apply in very, very few cases. It's possible they would do that here. I think that's the solution that some like Justice Kagan might favor. She was the big winner. She prevailed in Kaiser. That was her opinion, and kind of a triumph for her. In terms of other things that are upholding the administrative state, as I mentioned at the outset, Chevron is ultimately about implied delegations, right? It's a presumption that when there's a silence or a gap, Congress really wants agencies to fill in the details. Sometimes it's the correct assumption. Many times it's not. Many times the ambiguities and gaps are more imagined than real. But Chevron only deals with implied delegations. Doesn't deal with explicit delegations, which means that Congress remains very much free to say, you agency, pursue this goal by all means just and reasonable. You can work that out for yourself, and God bless. It's as absurd as it sounds, that remains a possible feature, and maybe it's not so absurd considering the way that the Congress has tended to legislate these last few years. So delegation is a big problem. It's not unrelated to Chevron. Right? Chevron is rooted in some ways in delegation problems. But I made reference much earlier in our discussion here to Schechter-Poultry, like the 1936 case. It was the last time that the court actually struck down a law for violating what's called the non-delegation doctrine. And at the heart of the non-delegation doctrine is the separation of powers understanding that Congress can't give away its legislative authority. Right? We kind of operate under some fictions right now, and Chevron permits this, where the kind of marginal or maybe not so marginal policymaking that agencies do is not really legislative, right? They're really just implementing Congress's legislative commands. Of course, the more intricate and detailed and expensive these programs get, the more they look legislative. But we're still operating under the fiction that a lot of these policy choices are not legislative. If we had a case that got to the heart of the problem, the non-delegation doctrine, that would go a much greater way towards limiting the kind of power and influence that agencies can exercise on their own. Doesn't make agencies unconstitutional, right? They would still exist. They could still perform a kind of advisory function to legislators and to the president. They could still assist in the very necessary tasks of implementing laws, right? The president is not running around personally implementing and executing laws. He has to direct and delegate to somebody. So it wouldn't end the existence of agencies, but it would drastically contract the sphere of independent action that they have. So yeah, non-delegation is probably the bigger core problem than deference. Now there is, I think next week you guys talk about the Jarkissi versus SEC case. That presents a non-delegation argument. It's one of the three issues. I would be kind of surprised. I was surprised that the court granted cert on that question at all. I would be more surprised still if that's actually how they choose to resolve that case, but it's out there as a possibility. A few years ago, there was a case called Gundy. It was a sex offender registry case. I won't go into all the details, but the important part for our discussion is that there was a 4-justice dissent in that case that indicated, hey, we want to revive the non-delegation doctrine. We think it's been neglected too long. We think it needs to come back. We think there need to be real restraints on the kind of policy discretion that Congress can give away. So the interest is there in a way that it hasn't been for a very long time. So there's a real possibility of that coming back. So litigators can pursue those avenues. Litigators certainly are pursuing those avenues. They are very much attuned to the signals the Supreme Court is sending to the bar. Yeah, that's I don't know about private individuals. In some ways, you just have to hope that you're never subject to any kind of administrative proceeding or enforcement action. The best you can do, I think, is attend to the ways in which your actual elected representatives are interacting with the administrative state. If it becomes an issue of broader political consciousness, then more and more elected representatives are going to have to attend to concerns about how many decisions they're passing on. Right. But it requires a lot of attention and energy from constituents to be able to hold their elected representatives to account for decisions where they're choosing not to decide. That's a mighty task.
Definitely think. Oh, go ahead, Kathy. I was just about to pass it back, but I'm concerned about the growth of the administrative state, as I'm sure many of our viewers are. So I think this is fascinating to see how it plays out. And thank you on behalf of me and everybody else. So pass it off to Kathy now.
Yeah, thank you. We've got so many audience questions that we want to get to. And we first want to give a shout out to teachers and students who are with us today. We have Grace and Faith Academy, Lizette Flores' students watching. And so welcome to you. And if you're a teacher and students watching and we didn't give you a shout out, just drop your information into the Q&A and we'll try to do that here in the last few minutes. We also want to thank our listeners on Las Vegas's KKVV 1060 AM. This show is aired in Las Vegas on Monday evenings at 6 p.m. Pacific. And we love our Las Vegas listeners, so thank you for listening. First, just want to read a comment from Hope Mucklow, who says, so informative and helpful. Thank you. Great discussion. So thank you. I mean, we've all learned so much today. And then Julianne Smith asks, if the Supreme Court limits Chevron, what can you envision changing regards to federal administrative state and limiting their power? I mean, what is it going to look like if Chevron, what's something different that we might notice if Supreme Court does put limits on this Chevron doctrine?
Yeah, so it ultimately depends on what kind of limits it puts on Chevron, right? It may not overturn Chevron, right? The outcome that she's referencing is a plausible one, that Chevron may survive like ours survived in Kaiser, just in some highly limited form. Now, what the kind of downstream takeaways from that would be depends on the scope of the limits, depends on how difficult they make it to apply Chevron. It also, I think, depends on how optimistic you are. The court has been sending signals for several years, even as it has declined to address the Chevron question. It has been sending signals for years to lower courts that you need to be much more engaged with the traditional tools of statutory interpretation when you have an agency case in front of you, right? This deference reflex needs to go by the wayside. Courts need to do the hard work of reading the law for all it's worth to determine what the real limits on agency power are. Maybe a limited Chevron doctrine would provide still more, fuel for that effort, the efforts to say to lower courts, work harder. Sounds kind of mean, but really dig into these statutes and don't assume that difficult or dense or prolix language forbids your entry, right? Figure out where the limits are reasonably. Don't make too many assumptions in agency's favor. If courts take that message seriously, broadly, there are lots and lots of just federal courts across the land, lots and lots of them. But if we get a generally greater skepticism from them in agency cases, a greater willingness to look carefully into laws, to carefully and soundly delineate the boundaries of agency power, then I think that in turn sends a signal to the agencies themselves that they need to be a little bit more modest in the types of projects that they are undertaking without really direct and express congressional authorization, right? People aren't going to work hard just to see their efforts like sent down in flames routinely, right? Again, unless you're really committed political partisans, people want to do good work, they want to make a difference, and they want to make a lasting difference. So if agencies are getting routine signals from courts that, hey, you've got to stop some of these more audacious claims to authority, I think they will start confining themselves to their more traditional roles and realms, and making what difference they can in those sort of well-trod paths and highways. They may start lobbying Congress for broader explicit delegations of authority if they feel that what they have on hand is not adequate. And I think lastly, what I'll say is maybe, hopefully, you would see presidents trying less often to take major policy priorities, things that were, say, part of their election platforms, and trying to put them into effect without having to engage Congress. That would be downstream of both of these things. But if the executive branch is getting a regular signal that these big consequential matters, you don't get to do them on your own, that could be a byproduct of a limited Chevron or an end of Chevron. Of course, there's court watchers who are listening to this are all thinking major questions. And that's a part of this too, but we're short on time, so I'm not going down that trail.
Well, we are getting very near the top of the hour, and we want to be respectful of your time. And we thank you so much for being with us today. I do want to close with a sort of a question and comment from Bill Koeneke, who says, do you agree with Winston Churchill's warning? Nothing would be more fatal than for the government of states to get into the hands of the experts. Expert knowledge is limited knowledge, and the unlimited ignorance of the plain man who knows only what hurts is a safer guide than any vigorous direction of a specialized character.
I'm inclined to agree very nearly wholeheartedly. It's a marvelous quote. One I only just recently encountered myself. I mean, literally just days ago. So it feels almost providential that this was raised in this call. It's a marvelous quote. It reveals just how timely and timeless these considerations are. I mean, I've situated this sort of growth of expertise as a rival claim to authority in the early 20th century, and Churchill commenting on it when he did, I think fits with that. But it's not new. We want to, in our political decision making, I think we want to do our best to rise above the immediate animal and material determinants of action, right? We don't want pleasure and pain to be what's guiding us in all our decisions. So I don't want a world where we're making no use of expertise, whatever. But we really need to be careful about interrogating it, cabining it, valuing it only for what it is. And expertise simply does not give birth to fully formed policy decisions without other value judgments. And experts are not the ones we want making the value judgments.
Well, thank you. We've all learned so much today. Thank you so much for your time and expertise and being on with us. And we want to thank our audience for all of your great questions and comments. And we want to invite everyone to come back next week when we talk about exactly what is the SEC, the Securities and Exchange Commission, and talk all about SEC tribunals and this next great case that we're going to be discussing this before the Supreme Court right now. So thank you all. And any parting comments, Lacey and Jewel and Jorn?
Thank you so much for a wonderful show. You were a very, very great guest. It was just a pleasure having you.
Yes, I'll just echo as well with Jewel and Jorn. Thank you for your wealth of knowledge, and me and I'm sure the rest of our audience learned so much.
And thank you for the great work of the Heritage Foundation too, Jack. It's just a wonderful organization and so many great resources. And we really appreciate all you do over there at the Heritage Foundation.
It's been my great pleasure to join you today. So thank you for inviting me.
Thank you.